Right, we've left the dreary realms of Scottish politics, and we've come to a much more interesting subject, which is encapsulated. Well, I say encapsulated because it's a millionth of a fraction of the whole subject, but we've got this fat, thick book here called the Oxford Handbook of European Legal History, edited by Heikki Pihlajamaki, who is the Professor of Comparative Legal History at the University of Helsinki, Marcus D. Dubber, who is the Professor of Law and Director of the Centre for Ethics at the University of Toronto, and Mark Godfrey, Professor of Legal History at the University of Glasgow. Published by Oxford University Press 2 years ago, and it's an absolutely fascinating book. And you'll notice, yet again, there's gannets here. It's that time of year in the background. It's rather nice to see them. Great fan gannets. So, obviously, I can't even begin to summarise the thing, except to say that it goes from Romans to pretty well today. It's got a total of 48 chapters, and before you get to the index, it's 1139 pages. It has got a couple of general essays at the beginning, which I think are exceptionally interesting, and I will just take a little bit before we get into the more detailed subject matter from this thing. This is James Q. Whitman, who's writing an initial essay just simply called The Historical Significance of European Legal History. The essence of government is the relationship between the rulers and the ruled, and there is one sure way of establishing what that relationship is, and that is looking at the legal relations. That's not to say what the law is, property law, mortgage law, law of delict, tort, whatever you like to call it, but how the power and the people interact. And that is essentially my subject, and therefore a book like this is of absolutely fascinating interest. And I'm afraid I'm being plagued once again by sandflies, which is a bit of a nuisance, but because they're all over the seaweed, the tide is going out, and it's liberated these flies, so you'll have to bear with me while I swipe away at the flies all the time. But James Whitman says that Timur Kuran's book, this is 2010, The Long Divergence, How Islamic Law Held Back the Middle East, is very, very interesting. And he talks about how Islamic law, for example, encouraged the equal distribution of inherited property amongst all the male children, as opposed to, and this is particularly relevant to Russia, because until the 18th century that was the system in Russia, because the rulers in the Kremlin had primogeniture, but for a long time the aristocracy did not, and therefore the power accumulated in the hands of the Kremlin at a time when it was not accumulating in the hands of the aristocracy. Medieval and early modern Islamic law, Quran suggests, maintained a strict norm of partible inheritance, which stood in the way of capital accumulation. This is exactly the same in Russia. Very interesting. By contrast, the widespread, though hardly universal, Western European norm of primogeniture permitted capital accumulation by a single heir, ordinarily the eldest son. Partnership and company law also figure prominently in Quran's account. And even more interesting, there's a section here on a recent scholar. The book was published in 2017, so it's very recent. A Chinese scholar called Taizu Zhang, I've never heard of before. In a detailed comparative study of Chinese and English developments, makes the case for the role of law as being the main factor in the great divergence in the 19th century between China and the West, in the sense that China was at least as wealthy, if not more wealthy, a part of the world than Europe. In the 18th century, by the 20th century, it was being carved up and it was being ruled by warlords and what have you. Anyway, that's the kind of observation that this book starts with. It's very, very interesting. The chapters that were of particular interest to me, and I think might well be of interest to people interested in Russia and the rule of law, include chapter 37, which is Russian law in the early modern period. It really takes it up to, I suppose, the end of the 18th century. And that's a very, very rapid canter over the ground, but nonetheless it's very interesting. And also British imperial law. We have the rule of law in Britain, but we didn't have the rule of law in the colonies or the empire, because law was not above the power in the land, which it has become in Britain, and that is what we mean by the rule of law. There, the power in the land set the law and changed if it felt like it, and the people could do nothing about it. So that's also a very, very interesting subject. There's also the development of the Scottish common law, which I think is a particularly interesting subject, because Scotland only had what we recognise as law applying to parts of the country that were under the control of the Crown in Edinburgh. So all around here, the Highlands, there was the law, the King's writ didn't run. And it's very, very important to understand that when you think about Scotland and its legal tradition, it's only the legal tradition of the, if you like to sort of call it the lowlands, although you have to exclude the borders, which are a war-torn area as well. And in areas like this, the law was the Duke of Argyll, with his court in Inverera. And if you did anything wrong in Campbelltown, you were sent up the loch there to Inverera to be dealt with by the Duke. Or, if on rare occasions the court came and sat in Campbelltown, the person who took the case would be the Duke of Argyll's cousin, or his youngest son, or his relative of some sort, and it was what was called heritable jurisdictions. They then appointed sheriffs latterly, and there were all sorts of other things, regalities, baronies, like Tarbert, for example, was a royal borough. Campbelltown became one later on. But law was a complete patchwork of jurisdictions, many of which were essentially presided over by a particular person and his relatives, and when that person died, he handed the jurisdiction on to his heir under primogeniture. It would be, generally speaking, the eldest son. So Scotland's history as a law-abiding nation is very, very different from England's, whereas where manorial law, which is sort of what this was like, was abolished by Henry II in the 12th century, with the introduction of common law in 1160-ish, around there, in the central courts in Westminster. So we have to be very, very careful about saying Scotland had its own legal system, which it did, but it also had its own form of legal anarchy, as you might call it, because the law was different depending on where you were, and the law varied in its application depending on the nature of your relationship with the chief. Now, some chiefs tried to adjudicate very fairly, others didn't, but it depended on the chief. It was a personal thing. So Highland history is not a history of any form of legalism, legality, respect for jurisprudence. It's a very different sort of history. There's also a very interesting chapter on communism and the law, which actually is quite good, because communism and the law is one of these subjects that people think there wasn't any law under communism, but there was, and it was used in a very interesting way, essentially to coerce people, but nonetheless there was law, and there's an interesting chapter on that. What I'm going to concentrate though on is something that is really in point at the moment, and that is the law of the European Union. Chapter 48, page 1115, Peter Linseth. And I will just tell you a little bit about Peter Linseth. He will be listed at the beginning here. Peter Linseth is the Olympiad S. Yoffe Professor of International and Comparative Law at the University of Connecticut School of Law in the United States. where he's also Director of International Programs. He has some very interesting things to say about European law, which is a subject I know a certain amount from experience, but very little about theoretically and as a subject. I've dealt with it with conservation law and seen the pernicious effects of things like the Habitats Directive and the Birds Directive in action in places like Islay and other places around the Highlands, including Arran over the water there, with the hen harriers. But Peter Linseth says that EU public law is best understood as a novel form of administrative law vis-à-vis democratic and constitutional government. And what that means in context is that essentially, once again, the law is above the government. The people have no influence, or comparatively little influence, no direct influence, on the law. The law is decided between the heads of government, who get together like barons in medieval Europe, decide what should be the case, promulgate their directives without any significant interference from the populace, and the European Court of Justice applies this, and it applies it in a very creative way. It's not only the European Court of Justice, also the European Court of Human Rights, which does that, and that has been the subject, and I highly recommend this if anybody is interested in this particular subject. Listening to last year's series of Wreath lectures featuring Lord Sumption, who talks about the way European law has become a form of legislation which is totally undemocratic, and it was originally established in order to preserve Europe from the abuses of constitutional law that had happened in the 1930s and so on. But it has turned into something which now dictates to governments the minutiae of what they may or may not do in a human rights sense. And that, he says, and I agree with him, which is one of the reasons I quote him, is totally undemocratic. Now what this is creating, together with the European Court of Justice, is a thing called the Rexstart, which is a German 19th century concept really that came to fruition, or particularly came to sort of flowered under Bismarck and the Kaiser, where the state agreed to obey its own laws. It didn't have to, and it could change that, but it basically obeyed its own laws. But it didn't allow the people any say in the formulation of those laws. And this is extremely well described here by Peter Linseth, where he says, and I'm going to read a short few sentences from this, the EU's authority has been and remains almost entirely normative and regulatory, and that is, it's telling you what should be the case. It's not just saying these laws have been passed, we interpret this action as having contravened the law or not contravened the law, either guilty or not guilty, in the sense that we have in Britain. It remains entirely normative and regulatory, even as EU judges, lawyers and law professors use a constitutional, in inverted commas, vocabulary to describe it. In other words, they're disguising the fact that this is really just the EU Commission telling everybody what to do. The EU's legal historical role has in fact been that of a pre-commitment institution in which national constitutional principles confer power on autonomous, this is a key word, autonomous supranational agents. Autonomous supranational agents. That is like the Court of Justice and the Court of Human Rights, although human rights are slightly separate, so let's concentrate on the Court of Justice. They're autonomous, that means they can do what they like. They're not subject to the rule of any form of parliament, and they are supranational. In other words, they cover all countries. So there's no single parliament, and there isn't a European parliament, as we well know. It's a weedy, powerless charade designed to give the appearance of some kind of representation, but in fact it has no powers, no meaningful powers. So, its national constitutional principles, these people, confer power on autonomous supranational agents to ensure a stream of policy choices in line with the original conferral. Right, so what he's saying is that the court makes policy. The court does not apply laws made by anybody else. These courts actually make policy decisions, like the Habitats Directive, like the Birds Directive, the way it's interpreted and written out, and the courts just decide that they will interpret them in this way rather than that way, and they're very vaguely worded, as we all know. That's half the problem with them, and therefore they have a very easy freedom to do that sort of thing. National constitutional principles, once again, the actors, the people, national constitutional principles do not necessarily control their supranational agents. So the Prime Minister of Great Britain has no control over the law that is applied, is made for, by the courts in Britain. There are supposedly mechanisms for the European Commission to have some kind of control. I don't think it's very much, but theoretically they're there. But there's none for the courts. National constitutional principles do not necessarily control their supranational agents. Indeed, the very purpose of supranational delegation has been to confer autonomy on the supranational agents. So the purpose of setting the European Court apart from the Parliament, the Commission, and most especially the national parliaments, is in order that they can act independently. And he says there are sound functional reasons for this, because you would never get a European a sort of coming together, a sort of European unification process if it wasn't organised like that. In other words, the only way you can get Europe to become a single governmental entity is by pretending you've got free courts, when in fact you've given the courts power to change everything subtly by legal means, which most people think you can't challenge, in order to drive things together at a practical level. Right, so we've said that there's this great set of institutions which culminate in the European Court of Justice, which is why it's so important that Britain, if it's going to have any meaningful form of independence from Europe, gets out from the jurisdiction of it. As he says here, the purpose of supranational technocracy was to build Europe without Europeans. I think that is one of the most extraordinary quotes I've read in a long time. The purpose of this supernatural technocracy, this sort of governmental technocracy, is to build Europe without Europeans. In other words, it's purely a theoretical invention of political nerds who want to control everybody. This is the final paragraph. I won't bore you anymore with this very important subject. In section 2 of this essay, called The National Judicial Dimension, Peter Lind says the following. Beginning in the early 1960s, enterprising litigation strategies pursued by private actors, together with the helpful support of the Commission Legal Service. Now, an enterprising private actor would include bodies like the RSPB, by the way. With the helpful support of the Commission Legal Service, helped to transform the court, there's the European Court of Justice we're talking about here, with the helpful support of the Commission Legal Service, helped to transform the court into perhaps the most effective supranational agent of integration. The supranational legal professionals in and around the ECJ viewed themselves, as one historical sociologist has put it, as, quote, the institutionalized carriers of the European idea, end quote, in the face of political resistance or reluctance. Further historical research has since uncovered the extent to which jurists pursued a conscious political strategy to advance the integration process through judicial means. The cornerstone of this approach was a method of treaty interpretation, the so-called teleological method, in other words, purpose of interpretation of these things, that viewed the commitment set out in the preamble to the Treaty of Rome to, quote, an ever closer union among the peoples of Europe, end quote, as the very purpose, the telos, of European integration. That seems to be slightly tautologous, by the way, that the purpose of unification was to get more unified. But anyway, but the point is that they take this as their job. They don't sit and say, what does the law say? they say, well, how does it serve integration? And this action that you've undertaken, how does that serve integration? That's putting it with ludicrous crudity, but nonetheless, the basic point is there, that it's not really, in our sense, a law court at all. It's a kind of policy chamber disguised as a law court. The court used the teleological approach, as well as the related doctrine of effet utile, whatever the hell that is, in other words, I imagine the actual, just simply the practical outcome, a functionalist notion, to overcome textual obstacles, ambiguities, or silences in the treaties to achieve the aims of integration as the judges understood them, looking to what they regarded as the spirit and general scheme, and not just the wording of the treaty. So the law doesn't mean what it says. The law means what the high Hegians think it ought to mean. Now that is back to the Middle Ages. That is how the Church, before the Protestant Reformation, and before the English Revolution, and before the revolution in 1688 and the independence of the judges in 1701 from the court, that is how it worked. So Europe has been taken back to the Middle Ages in order to bamboozle the population into thinking that integration is the law. And it's not really the law, it's just some people's desire, maybe everybody's desire, fine. But it isn't the law. This is nothing to do with the rule of law. This is to do with the implementation of the aims of a certain sort of person who happens to be in control of the European project. From this perspective, as a member of the court would later put it, the drafters of the treaties purportedly built a preference for Europe into the genetic code transmitted by the court. So I think really there's nothing more that needs to be said. We understand that this court is not controlled by anybody. The law is an autonomous entity which has nothing to do with our understanding of law, which is making certain acts and things permissible and others impermissible in order that society can operate in a cohesive and reasonably freedom-orientated way. It has nothing to do with that. It has absolutely nothing to do with that. It's an autonomous body which is trying to create in Europe a kind of a super-state by deception. Now that's just one example. All these other essays are equally interesting, I'm sure. I haven't read all of them, by the way, but I've read some of them, and it's great stuff. So, it's the Oxford Handbook of European Legal History, and I highly recommend it. If you want to consult it, go and find your library. I don't know if you can even, it may even be possible to do it online, I'm not sure. But I doubt you'll have to pay, but that was fine. I'm sure it was expensive to produce. So, there we are. That's it. And it's another beautiful day.